I'd like to simply state that I do not understand the nature and cause of action in regard of the elements of my personal jurisdiction.
All right. Are you entering a plea of guilty, not guilty, or no contest?
Can I enter a plea at the moment because I'm not sure what I'm going to be tried under.
Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well. Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties and a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
Well, on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of action in regard of the elements of my personal jurisdiction, the venue, and the nature cause of action until the prosecution has properly allegedly that before me, and therefore I'm not able to enter a plea until then. I'd like to know if...
Buckle up, guys. Today, we're stepping into a courtroom showdown where logic and legal reality collide. This man boldly claims he can't enter a plea because he doesn't know what jurisdiction he's under. That's a classic sovereign citizen playbook right there. But the judge, calm and composed, sticking to the facts while this guy floats into legal fantasy land. The idea that not understanding the court somehow protects you from it? Yeah, that's not how it works, and the judge is about to make that crystal clear.
You said so.
Okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me with regards of the elements of our personal jurisdiction, and also the nature cause of action until the jurisdiction, the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it maritime amity law. So I can know how to defend myself, and then I can enter my plea.
All right. Have you filed a motion for discovery in this case?
I filed in I put a special appearance in affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I faxed the special appearance. Did you receive it?
There's a document that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature and says respondent beneficiary of the named defendant constitutional rights / benefits.
It should
Is
be
that
like
the document you're referring to?
Yeah, I think is it just only one they went through? Because there's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a 1-page document.
There's only one. It's supposed to be more. I faxed the more over there. It was supposed to be like 4 pages.
It's 1 page. Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
Yeah, I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
Can I enter a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action brought up yesterday.
Well, I've explained what you're charged with.
Yes.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to,
All right, guys, this is where things start heating up. The judge explains the difference between guilty, not guilty, and no contest, laying out the legal roadmap with clarity. But instead of answering, our guy spirals into questions about venue, jurisdiction, and, wait for it, common law versus maritime law. He's trying to turn a traffic offense into a constitutional crisis. It's like he's hoping to trigger a legal trapdoor, but instead, he's just getting deeper into confusion.
I need to enter that in beforehand. How can I reset it so I can do that? I have time to do that. I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address, they need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. But I'm going to set aside 2 hours for bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial.
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. It'll give you an opportunity to place your written motion for request for jury.
Here we go again. He's back on the mic, repeating his confusion like it's a legal shield. The judge asks for a straightforward plea, but this man insists on fishing for a loophole that doesn't exist. His talk of special appearance and personal jurisdiction sounds impressive until you realize it's just recycled rhetoric. Meanwhile, the judge keeps things professional, patiently trying to move the case forward. You can almost hear the sigh behind that judicial tone. Now it gets technical. He claims to have faxed a multi-page affidavit, but only one page made it to the court. He insists the judge must be missing the rest, as if the missing pages might contain the golden ticket. The judge flips through the record and, unsurprisingly, finds nothing official. It's classic sovereign citizen strategy. Flood the system with pseudo-legal documents and hope it stalls the process. But this court isn't biting. The judge finally has enough. Since the man refuses to enter a plea, he enters a not guilty plea on his behalf and moves to set the case for trial. And just like that, the sovereign script hits a legal wall. No amount of vague language or notary stamps will erase the fact that he was driving without a license. The judge's quiet authority shows that legal facts always outlast legal fiction. No matter how much paperwork you throw at them. Watch this part closely. The man tries one last time to delay proceedings so he can resend his special appearance. But again, the judge isn't swayed. He offers him fair options: file your motions properly, follow the law, and prepare for trial. It's a teachable moment. The courtroom isn't a sandbox for fantasies. The rules are clear, and trying to bypass them with vague legal jargon? That only tightens the noose. Now he pivots, requesting a jury trial instead of a bench trial. But there's a catch. He never filed the written motion required. The judge, still patient, gives him a path to do it right. It's ironic. After all his resistance to court authority, now he's asking for the full weight of a jury. But a fair trial demands you play by the rules. And for someone who claims the court has no power, he's doing a lot of asking with. Guys, this one wraps with a reality check. He's heading for a jury trial, but don't expect a miraculous win. He was caught driving without a license, and no amount of sovereign talk changes that. His defense is weak, his filings incomplete, and his courtroom strategy more fantasy than fact. The truth: once you're in court, there's no loophole to wish your way out. Like the video, subscribe to the channel, and we'll see you in the next video.